Hello, good afternoon, everyone. We're going to go ahead and get started. My name is Faustine Chan. I'm the Business Innovation Manager for BBB serving the Pacific Southwest. We've been holding these daily webinars just to give our businesses tools at this time, education materials just to help them navigate through these times. If you would like to sign up for webinars that are upcoming, you can go to events.bbcommunity.org. You can also view past recorded webinars on there as well. And then this webinar is being recorded, so if you do miss any part of it or if you do need to review the information, it will be posted on that website as well. We also have, I want to just make a quick announcement on, we have a Main Street Matters grant that we're holding, our BB serving the Pacific Southwest regional area that we service. And this grant is to just help some of the Main Street entrepreneurs that are currently struggling right now. We understand there's a huge business need. They're not getting the PPP loans, the emergency funding that the government has offered. So if you're interested, if you're a business that's struggling, please submit an application. It's free to apply. We are awarding different quarters for about 3 months, different amounts to different areas. So please apply. It's free to apply. Just go to mainstreetmatters.bbcommunity.org, and I can share that in the chat option as well. We're also looking for sponsors. If you'd like to make an individual donation or become a sponsor, please go on that website as well. We've actually received over 600 applications in our service area, so there's a huge business need. We really want to help all these businesses out as much as possible. So thank you for that time. So today I want to get started to our webinar. We have a fantastic speaker today. I want to introduce Brian Burt. He actually serves on our board of directors for BB serving the Pacific Southwest as well. He's a partner with Snell Wilmer. He serves as the chair's firm's emerging business group. He's also been selected for inclusion on the Best Lawyers in America, Arizona's Finest Lawyers, and Southwest Super Lawyers Southwest Rising Stars list. He's a business lawyer advising entrepreneurs and emerging growth companies in all stages of development, from formation to liquidity. He also holds a BA in political science and philosophy, and he's also earned his JD from the Harvard Law School, where he served as the managing editor of the Harvard Journal of Law and Public Policy. So please welcome our speaker today, Brian Burt.
Thank you very much. Can everyone hear me okay? All right. Well, we're going to get
Yes,
right
we hear
into
you
it.
fine, Brian.
Thank you. Thanks for that introduction. We're going to get right into it. Just a quick couple of notes on the firm for those who may not be familiar with us. We've been around here in Phoenix for about 82 years, and largest firm here in Arizona, with offices kind of throughout the Southwest and some new offices in the Northwest region as well. True full service firms, all the resources you might need to help start, grow, and sell your business. A little listing on the screen there. And a lot more information available on the website, including a weekly emerging business blog, which is something I do each week, and it's a collection of articles of interest to entrepreneurs and their companies. So if that's you, I encourage you to check that out. Today we're going to cover kind of 10 key tips and really 10 areas of the legal arena, which come back to kind of bite folks on a daily basis. We see lots of clients come in with these issues, and as we go through the presentation, it's going to be about an hour or so, and we can stick around for some questions at the back end. So if you would, you can put those on the question list there, and Faustine will take those, and we can kind of aggregate those and answer those at the end of the program if that works for everybody. Kind of keep it most efficient. And we're going to go through everything pretty quickly, so you may want to check out the recorded version of this. I'm also happy to send you a copy of this program just to have for reference if that's of interest. So again, in thinking through some of these, you will ask, why are we talking about this? Some of this seems pretty common sense, and everything we're gonna throw up on the screen today, again, are things we see all the time and can cause significant damage to your business enterprise, sometimes can kill that business. And so we'll walk through these, and each topic you'll see some sub areas. Again, a lot of information to kind of take in. So I encourage you to, again, ask questions. Happy to follow up with you offline afterward as well. And we'll start with number one here. Selecting the wrong form of corporate entity. Typically, we have people kind of raise their hands and do some audience participation. Obviously, we're limited given the virtual format here today. but I suspect most of you are either in the LLC format or are in the corporation. It could be a C Corp or an S Corp. And here are your typical options. Lots of people start out one way or the other, not really thinking about what the kind of long-term vision is for the company. Perhaps your CPA gives you some advice, maybe you had an attorney give you some advice, maybe a friend did something, so you follow that. And what we're going to do throughout the presentation as well is talk about what I call myths on the street. So things that people think are true. Again, they may have heard it from a friend that has a business, they may have read it somewhere, but unfortunately not the case. And one of those is that only corporations provide maximum liability protection for your personal assets, and that is not the case. If you set up any of these entities and do it the right way, operate it correctly, they all offer equal liability protection. I'm a fan of the LLC as a starting point. There's times when the corporation is appropriate, but the LLCs offer maximum flexibility in terms of structuring the ownership relationships, the economics, the management, etc. And there's no corporate level tax. So unless you want to pay more tax than you need to, you'd ideally like to have an entity that has got pass-through tax treatment, meaning you only pay tax at the owner level and not the corporation level. Both the LLC and the S Corp offer that flexibility. The S Corp has lots of restrictions in terms of your ability to bring in capital, to incentivize other owners, the number of owners you can have in the business. You can only have human beings as owners typically. So it does provide lots of restrictions if you're in that S Corp structure. The only time you have to be a corporation from a legal standpoint is if you're going public. And to the extent that that's not something that's in your future, then you can do almost anything from an LLC perspective, including raise capital. That's another one of those myths on the street where folks indicate you can't bring money into the company from investors unless you're in a C Corp, maybe a Delaware C Corp, and that's simply not the case. The S Corp is also a pass-through entity, as I mentioned. The issue with that is that those restrictions come into play. There are some benefits from a tax withholding side to you as the owner and employee, and that may be why your CPA recommends that approach to you at the beginning. I can tell you that unless you plan to keep the business fairly small, and you may, that benefit typically gets outweighed pretty quickly by the restrictions that prevent you from doing the things we describe. So there's not one size fits all, but typically an LLC is a good place to start. If you're in a C corporation, then you are getting taxed at both levels. And to the extent that that's where you are, you may want to consider converting into a different form of entity. And like with almost every issue we're going to talk about today, if you have this issue on your plate and you think you might need to take action, usually time does not help the problem. Typically it gets worse as the problem kind of continues here. As the company appreciates in value, the potential tax consequences of converting your entity only get bigger. So we're going to try within time constraints to kind of tell a few horror stories along the way, things that we've picked up, cases that we've worked on, real life problems, because I always found it's helpful to kind of give you a kind of a story to go with the problem. In this case, we had a corporation here locally in Phoenix, and they had passed the corporation on to second generation owners. And we were brought in to help the second generation transition to third generation. Problem is, we could help the third generation not have a tax issue, but the second generation was stuck with a company with $20 million worth of value. So when they go to sell and transition it to that third generation, it's stuck. You're stuck with a tax bill much greater in the millions than would be the case if they had that LLC in place before that transition. So again, just a quick story to indicate that these types of things seem insignificant when you're just getting started, but to the extent that you grow and become successful, they multiply as you go forward. Number two, not protecting your corporate shield. So most people put the entity in place and think that that's all they need to do. And you file your articles or your certificate with your state, whether it's Arizona, California, or otherwise, and you're on your way. And operating a business from an entity is a good first start, but you also need to make sure that you prevent piercing of that corporate veil. And there's three things we'll quickly touch on that you need to consider. One is to maintain corporate formality. So lots of people who put corporations together don't maintain separation between the personal assets and bank accounts and other things and what they're doing with the company. And if you don't keep the company separate, then the creditors who may come after your company, whether it's an employee, it's a customer, it's a vendor, aren't going to try to keep those walls in place either. And they want to go after the individual assets that you have outside the company, be it retirement accounts, your cash in the bank, your house, etc. You want the worst case to be, if things don't go well for your business, to bankrupt it, shut it down, and live to fight another day with maybe a different type of business, different entity, etc. You don't want those personal assets to be put at risk. So making sure that that corporate shield stays in place is critical. Number two is undercapitalization. So to the extent that you think about starting a company or expanding it, you have to have enough capital in the bank in order to make sure that your company can function. To the extent that you go out and rack up 50 grand worth of startup costs, lease space, hire employees, and do other things, and you only put 5 grand into the company, hoping that the rest will come from future revenues, you may find that doesn't work, and business didn't kind of kick in as quickly as you hoped, and as a result, you're left with some big bills to pay and no money in the bank to pay it. And in that case, it would be easy for the creditors to argue, hey, you spent 50 grand, company wasn't generating any revenue, and so you've undercapitalized, and therefore we're going to come again at your personal assets to take care of those obligations. So fraud, and we're not talking about the fraud that you may be thinking of, and hopefully no one on the call is contemplating that, but what we see and what we're talking about in this context is where people, for example, will go and have a non-compete with an employer. They leave the employer to set up their own company, and they say, hey, I'll set up a company that can compete. It won't be me individually, so no issue there. In this case, you can't get around an obligation you entered into personally by simply putting yourself into a company and doing what you couldn't do on your own. And so that would be another instance where they go after your personal assets. You can also have personal liability in these capacities. We're not going to touch on each of these. The big one, well, two big ones. One, if you do individual kind of bad acts, if you violate the law, etc., then you can expect to have some personal liability. The other big one, which we'll talk about, is a guarantee. So lots of you are going to be guaranteeing obligations. Maybe it's for an SBA loan, maybe it's for the lease that you sign with your landlord. And the tip here is to make sure that you monitor and ideally get off of those personal guarantees as soon as possible. The unfortunate story, I think this is the worst one we talk about in this presentation, is this was back in the last kind of Great Recession back in 08. And if you were in business back then, you recall that it happened pretty quickly. People didn't see it coming, at least most of us, and it hit pretty hard and pretty fast. And so right before that happened, we were shopping a company to represent it in the sale of the business. Looking at a very large transaction, tens of millions of dollars. It was a family business, very nice folks who ran it. And they were looking to get that sale done in the fall of 2008. And there were millions of dollars worth of personal guarantees that the company had. But the thought was, why pay those off? We'll just deal with that when the sale closes. No reason to go through the trouble of paying those off and have kind of two rounds of transactions. So kept the guarantees in place, didn't do anything about it, could have paid them off fairly easily out of the working capital for the company, but again, didn't do it. Within a period of 60 days, went from taking home more than 50 million in potential sale to finding the company in bankruptcy because the market crashed and they were in an industry particularly hard. And you can see what's coming next, right? The personal guarantees get called by the banks who wanted to be made whole. And so not only did the company go under, but the owners found themselves in a very difficult position as well. So again, talking about just having the worst case be bankrupting the company and not yourself. This was a tragic situation and one that was easily avoidable had they taken those personal guarantees off the table. Number three, putting all your corporate eggs in one basket. So We talked about just a few minutes ago, making sure that your company, your corporate shield is in place so that worst case is you go home and start another company and protect your personal assets. There are ways within your own business to structure it so that you protect one piece of business versus the other. And there's lots of ways to do this. It could be a parent and subsidiary structure, so one company owning another, or it could be two companies that you own separately, kind of side by side. And in terms of how to think about this, let's say you own a piece of real property, you own the office building that your business operates out of. It may make sense to create a LLC, stick the business or stick the real property in that LLC, and then lease it to another entity, perhaps another LLC that operates your business. So if something happens either on the real property side or more likely on the operating business side, you will be able to contain the damage in one entity or another and not take down the whole business. And that real property may be protected in that other entity. And sometimes, as you may know, if you've done this, that property may be worth more than the business itself. If you have intellectual property, patents, other things, that may be something you can put into a different entity and license it back to your operating company. Another way to make sure that gets protected if the operating business goes down. Another way to think about it is to separate out lines of business. So if you are involved in business in different areas, maybe from a geographic standpoint where it's very different rules and regulations, maybe you're doing some business abroad, that may be a time to set up another entity to account for the risk difference and exposure between those two geographies. Same thing with if you're doing different types of services, different types of products, and some are much riskier than others and likely to bring some claims. You may decide to separate those out into two entities as well. And again, segregate that risk one from the other. So lots of ways to do it, but ways to, again, manage that process. There's some issues that go with that. The earlier you are in the process of your company, I suspect we probably have some on the call that are fairly young in terms of how long the company's been around, and others that may have been around for 10 or 20 years. You can always do one of these reorganizations, obviously a little bit easier if you are kind of newer to the process and haven't been around that long, but still capable of doing it at any time. The lesson learned here is that we had a company where they had been building a software product within the existing operating company. So they were looking to eventually shut down the existing company, use this new software platform in a totally different space, and didn't bother to set up a new company to develop it. Spent a couple $100,000 developing the software, and it was all owned and contained within the existing operating business. Unfortunately, they got hit with the class action lawsuit before that software was moved to its new entity. And as a result, the people suing the company had a right to that software if they were to win that litigation. So long story short on this one, the only way to preserve and protect and get at that software was to move it to a new company. And you can't just take it out and not put any cash in because, again, if they won the lawsuit, they would have a right to take that asset just like all the other assets of the company. So they ended up having to buy the software from their existing company, from their new company. And so fortunately, this has a good ending. They settled that lawsuit and they were able to essentially just pay themselves, making payments from the new company to the old company for that software. But had they not, they would have eventually had to pay double for it, replacing a couple $100 worth of software value for cash, and then giving that cash out to the existing people. So lesson learned here is to think about taking those corporate assets, creating different entities in which to operate those, and of course maintaining those differences between the companies as you would your individual company. If you're leasing property, you've got to have a lease in place. If you're licensing intellectual property, you've got to have a license in place. Something that would approximate what you would do with a independent third party. So again, we typically take a show of hands here as to how many people have partners in their business. I suspect at least a few of you do on the call. And this is one of my favorite topics. If you've had a partner or currently have a partner, you know that partners will disagree. I don't care if it's a lifelong friend, it's a family member, it's someone you just met last week. Eventually, people that you are partners with in the business will have disagreements, and there is no way to resolve those in the absence of a good shareholders, or if you're in an LLC, operating agreement. Lots of people, and this is one of those myths on the street, assume that there's a default set of rules in the Arizona statute, the California statute, or whatever state you're in. And unfortunately, that's not the case. The default rules don't exist. And to the extent they do exist, they produce results that typically aren't what you would think. They're not intuitive, and they don't resolve most of the issues that you may encounter. And so when you don't have an operating agreement or shareholders agreement, it kind of gets chaotic pretty quickly. The purposes of putting one of these in place kind of are all of these things you see on the screen there, to align the expectation of what is going to happen to the company, in 5 or 10 years. It's going to allocate the management, economic, and information rights. Who's going to run the company? How are you going to distribute profits? Who's going to get access to information? It protects the enterprise value and facilitates orderly transition. There's going to be people, owners, who come in and out of the company. It's not unusual whatsoever for one owner to ultimately decide, they want to go do something else, or there's a dispute and you decide it's best if you part company. Having an orderly way to do that is critical in order to preserve the company, its value. There's few things that customers like less than to deal with a company where the management, the ownership, etc., is kind of going at each other. That does not build confidence and encourage customers to patronize your business. There's a million stories that we could talk about in terms of lessons learned. And this typically happens more so in times like where we are today, where there's an economic downturn. Things aren't going as well as they could be, and partners tend to have differences of opinion. Maybe one wants to continue, one wants to pull back, maybe one has personal financial issues and needs to take action. So we see much more of this happen in these types of economic downturns, and you may be seeing some of those out there as well. The story on this one, real quick, comes from the kind of last downturn when lots of partners were kind of going at each other from a litigation standpoint. We had one guy who was an investor in a local Scottsdale business, and he was the investor. His partner was the operator. He didn't know anything about the business, but he had the financial resources to put in, so he did that. And in that capacity, he guaranteed the lease. And the other individual had a falling out. That person literally in the middle of the night decided to take the assets and move them down the street, set up a new business, competing business, and kind of stick it to our client saying, hey, if we're not going to get along, I'm just going to go do my own thing. And so our guy was left with an empty space, but a personal guarantee on the lease. And of course, as you might imagine, that landlord called the guarantee, and there was little that our guy could do to facilitate recourse to the other guy, because that other partner had virtually no assets. There was nothing in place from an agreement standpoint to kind of go after the new business. He could have, obviously made claims against him for what he did, but there was very little he could do easily in the absence of that shareholders operating agreement. So lots of lessons learned on that front. And if you've got a partner that you're in business with that's a family member, lots of people say, hey, it's a parent, it's a brother, it's a spouse. Those are the nastiest disputes we see, because you've got the business layer, and then you've got the personal layer on top of it. So to the extent that, and we hear this all the time, it's a family member, so I'm not going to worry about it, we'll figure it out. Certainly as much reason, if not more, to get that operating agreement in place. Number 5, raising capital. I know a few of you have attended some of the programs I've done on raising capital, and we're going to kick those back in the not too distant future. So if that's something of interest, we will be hosting some additional raising capital programs, hopefully starting maybe next month or the month after, maybe virtual, but put those back in place. Probably the takeaway here is, if you're raising capital from a bank, you're getting a loan from, whether it's Desert Financial or it's another financial institution, or it's you're putting your own capital in, etc. No issue there, right? That's just a normal loan transaction, or again, you're self-funding. What we're talking about on this slide is if you could do almost anything else. If you go out to bring in investment from a friend, from a third party, from a venture capital firm, or it could be a loan from any of those parties, you have to follow the securities rules. And the easy way to describe this one, the easy takeaway is if you don't get it right, it's a felony. So that's not typically something you want stapled to your entrepreneurial resume. And so you've got to follow the rules. This one gets pretty complex, so we're just going to kind of give you the high level. Suffice it to say that the minute you start talking to people about putting money in your company, that's when those rules kick in. And you have to make sure you're complying on both the federal and the state level. And unlike a lot of the entrepreneurial things we talk about, where cutting corners can compromise the potential of the business, sometimes it can put the business under. This is one of those areas, and the only one we're going to talk about today, where you really want to make sure you follow the rules very closely, not one of those areas where you want to cut corners. Other places, it's going to be up to you, what kind of risk tolerance you have, but this is not one of those places. All of the offerings that you do have to, again, comply with federal and state law, and those, what we call exemptions, another way to think about it is kind of the legal paths that are available. There may be one path, there may be 5 paths, and depending on what you're doing, you see on the screen there, depends on the number of people investing, where they're located, how much money you're raising, type of vehicle you're using to raise capital, etc. So you may have one path available to you, you may have 5 paths available to you. Once you figure out which paths are available, you want to make sure that you pick the one that's most likely to yield success for your business. Just because it's legal doesn't mean it's likely to be the best way to do it. For example, lots of folks ask about crowdfunding, which is still relatively new. They've seen kind of the Kickstarter model, and they know that there's ways to do that from an equity standpoint instead of giving out T-shirts. In a Kickstarter campaign, they give out equity to their company. And that's seems attractive for lots of folks, but there's lots of rules associated with it, and it really is a certain type of venture, kind of certain positioned at a certain time of its life cycle that's going to be attractive to those people interested in the crowdfunding side. So again, it's not a one-size-fits-all type of deal. The minute you talk about raising capital, that's when those rules, as I said, kick in. So the conversation is one you have before you go too far, before you start issuing a term sheet or talking to people about what you want to do, etc. That's the time to jump in there is at the front end. In terms of other requirements, there's going to be disclosure that you have to give them. You've got to be careful of intermediaries who will promise you the ability to bring in capital, but again, unless they're officially licensed to do that, and for time's sake, we won't get into all those details, but that's something to pay attention to as well. So again, just recognize this is one of those areas where you want to get some professional support to make sure you do it the right way. Number 6, and I see we had someone raising their hand there, so I don't know if you can type out a question. Happy to answer that if you want to put that into the question box. If not, we'll come back to it at the end. So number 6, failing to protect your intellectual property. So every company has intellectual property. Some people on the phone may say, hey, I don't have a high-tech company with a patented product. That's just not what I do. I have just a regular restaurant business. Well, everybody has some intellectual property, and first step is to identify what that is. It may be a patent, or it may just be the trademark that your business uses. Maybe you sell widgets, but you have that business name that's out there, and that's a big part of what distinguishes you from one business, from your business versus the competitors. And you may have a logo. You may have some trade secrets in the business, maybe a proprietary way to do what you do, a proprietary formula for the product that's different than the competitor's recipe. And that's what distinguishes you from those competitors. So first step is to identify what you have. And then the second step is to confirm that you actually own it. And this is one of those things, kind of the myths on the street that people tend to believe, and that is that if you get a third party to create some IP for you, whether it's a partner, it's a consultant. Think of you on the phone here who maybe have someone who created their website for them. They prepared your logo, maybe did some other things for you, and you paid them whatever it is you paid them, and you assume because that transaction happened and they were compensated that you own whatever it is they created, that website, that logo, etc. Unfortunately, that's not the way that works, and the law says unless you get a assignment of an intellectual property agreement, that ownership is going to default to the party that created it. So there's lots of situations where people spend lots of money on pretty core assets of the business, only to find out when they go to raise capital or more likely sell the company. And folks like myself come in and do the due diligence. You say, hey, those trademarks that you have for the business aren't owned by the business. And now you have to go back out to the people you created the work product for you to see if they'll sign that over. Sometimes they will, sometimes they won't. There's ways to protect both from a legal and a non-legal strategy. And I think lots of folks are paying more close attention to this given the data breach issue is pretty hot these days. Obviously formal ways include patent and trademark registrations. You can protect the patent and trademark at the federal level by filing a application with the U.S. Patent and Trademark Office. You can have and should have confidentiality agreements in place with your team, whether it's your employees and contractors who do business with you to protect that information. If it's legal in your state, it is in Arizona, not so much in California. You can have employees sign up for non-compete agreements and anti-piracy, so they can't steal customers, they can't steal employees after they leave your business, stop working for you. You can prevent them from setting up shop or at least trying to pull your team away from you, your customer base away from you after that happens. Again, it's state specific as opposed to, in connection with where the employee lives. Again, Arizona, if you draft it narrowly enough, you can enforce those. California makes it illegal in most cases to have a non-compete or a anti-piracy of customers after someone leaves their employer. So you got to be careful as to how you do that. And then assignment of inventions to hit the issue we just talked about, making sure you own the stuff that your team creates. And then of course there's non-legal stuff, just making sure that your software system, your computer system at work is only accessible to the people that need to be in there. Maybe certain files are restricted to management, or certain technology secrets are only accessible by those who are working on that particular project. So taking steps like that to make sure that you've locked things down is always appropriate. So the lesson learned here, just a quick story. We had a company we were selling for very nice sale price, kind of $20, $30 million range. This happened a little while back. And the core value of the company was the trademarks on the products. So it was a product that maybe you bought and was in the stores, and they didn't have any proprietary formulas per se. They weren't patent protected products. It was really the brand names that they had for the individual products, and they were able to market those and get good brand recognition for its customer base. And so that was a big part of the sale price. And when we went to do the deal, found out that they had not done this assignment of invention agreement, which is literally, it's a page at most, maybe a half page in some circumstances. It's not a big document, and it would cost very little to put in place. And that's one of those kind of themes throughout today's presentation is most, if not all the things we're talking about on the call today don't cost a whole lot. Some you can do for a couple $100, some you can do for a couple $1,000. Some are free to implement. And the damage that they cause by not doing it is always at minimum, kind of the minimum damage is it will cost you, in terms of fixing it, it'll cost you what it would taken to do it right on the front end. Typically it costs you many multiples of that. And so that's just another kind of takeaway for you. Once I get the call and people say, hey, I didn't do X, what's it going to take to fix it? Unfortunately, it's usually saying, well, if it costs you $1,000 to do around the front end, now you're fighting with maybe a vendor who didn't sign this over. We've seen plenty of circumstances where it costs you many thousands to get that back from the person who didn't sign the document. In this case, going to sell the company, they didn't own a single trademark because they hadn't done the assignment process. And we ended up chasing people around the globe between the Christmas and New Year's period because they were trying to close the deal by year end. And people application in order to get them to sign over those brand trademarks. And this was a good ending as well, because fortunately they were on good terms with these people. They didn't extort them, as we've seen in other cases, knowing that the company was selling for a lot of money, and they could have done that and probably could have gotten paid, but didn't do it. But it certainly was pretty stressful there at the end for the seller, who again had $20-30 million purchase price on the line and was counting on A, being able to reach these people, and B, getting them to sign things over without extracting a pound of flesh for it. Number 7, managing key employee issues. So I suspect most, if not all of you, have maybe, whether it's one employee or it's 100 employees in your business, and lots of you will continue to add employees to the bench as you grow the company. So we're going to just talk very briefly in this one about the issues you should be paying attention to. Right now, these issues are red hot. They were red hot before the virus hit, and now you're dealing with all sorts of additional issues on top of that, based on how you're going to reopen your business, when can you reopen it, how's that going to work. And I know there's lots of seminars, our firm's doing a number of them as well, kind of guiding folks through that process. So if that's of interest to you, let me know after the program, and we can make sure you're on the list to access some of those free resources. The statistic, which obviously that was a statistic I got when I did this presentation probably about 3 months ago. So you saw 43% of employees were looking for a new job. Obviously, things have changed radically since that time, and millions of folks are out of work. So it's clearly going to be a kind of a buyer's market and employer's market as things open up. That said, all these other issues are important. Ensure proper hiring and firing. Every state has its own set of rules about what you can say, what you can do, how you bring people into the company, and equally important, what happens when they get asked to leave the company. So you want to make sure that not only the proper documentation is in place, but the proper questions are being asked and processes are being followed in order to avoid buying yourself a claim. You also want to understand what employees want. And again, for time's sake, we're just going to touch on these very briefly. But as you may know, there's a new group in the marketplace. Some of you on the phone may be millennials. We have lots of them in our firm. And at this point, they're about 50% and growing in terms of the employee base. And it's a very different way of interacting and incentivizing that group versus maybe some other groups that have been historically working for your business. And so, things that and interest, what they're interested in and how you motivate them. The good news is lots of those things don't require a lot of expense, whether it's telecommuting, which we're kind of all doing these days, or it's kind of flexible hours or other things. Again, things that don't cost your business a lot, but are important to that segment and to be considered when you're figuring out how to attract and retain those employees. You can do it with employment agreements, different types of benefits, which are really important to folks these days, particularly in these times. Performance bonuses, and there's ways to give what I call kind of a piece of the pie there, as you see on the screen, whether it's actual ownership or some other type of bonus or phantom ownership to incentivize whether it's the whole team or key employees to step up and do what they need to do. Other red hot issues include, and this is probably almost everyone on the call has encountered this or will encounter this, and that is, do you make the employee, make the person working for you an employee or a contractor? And most entrepreneurs like to default to the contractor approach because they don't have to bring them on, pay taxes, etc. It's easier to do from an administrative standpoint. And like with many things, just because you and that person agree to make them a contractor doesn't make them so. There's all sorts of rules, both on the federal and state level, that determine, based on the compensation, based on the control you have over them, based on the role they're playing with the company, whether they can be a contractor or an employee. So if you haven't done it recently, encourage you to think about going through a kind of a contractor/employee audit and talking with someone. We have folks that can help you do that to see whether you're in the gray area or over the line as to how you're treating folks. The consequences can be pretty significant. Employment arena, to the extent you failed to properly characterize someone or pay someone, Can add up to multiples of what you would owe them in terms of wages or compensation. There can be kind of triple damages. There can be personal liability. This is one of those areas, and there's not that many of them, but this is one of those areas where you can actually be personally liable as the owner of the company if you fail to do it right. So it pays dividends to kind of get that locked down. The next thing is at will or employment agreement. Most of you say, hey, I have to hire someone, I'm going to pay them a salary, and that way I can make them work 2,000 hours and not worry about it, not have to track time. This is another one of those areas where you don't get to determine exactly how they're characterized. There's rules that determine whether they're eligible to be a salaried employee or they have to be an hourly employee. And important to understand the differences. And again, unfortunately, it's state specific. So if you've got a business in multiple states, you need to figure out what's appropriate for your state. And then the at-will or employment agreement is simply whether they can be terminated kind of at will, as the name suggests, or whether you have to pay them a severance in order to get them out of your company. And so figuring out and properly documenting that is important. I can't tell you how many times people come to us with forms that they pulled off the internet, they got from a friend, that really have no relationship to what they were trying to accomplish. They aren't even geared toward the state that they're in. It's kind of a one-size-fits-all, and it ends up being a pretty big mess. They think people are at will and end up having something signed or an employee handbook that suggests otherwise, or they hire people as contractors when they're supposed to be employees and so forth. So there's lots of ways to kind of get yourself in trouble. The best advice here is to go through again, kind of an employment audit to figure out where you sit, something that can be done very cost effectively and kind of get you on the path. So discrimination, harassment, always red hot topics, and there's steps you can take within your business to minimize the company's liability if something happens. You can't prevent some joker from doing this in your company. Of course, it may happen, but what you can do is have protocols in place, reporting in place, and a quick response kind of mechanism in place to limit the company's exposure from a legal standpoint. So if some bad actor does do something, he or she may be obviously on the hook, and the company may as well, but you minimize the liability because you've taken steps to constrain that. Number 8, failing to use commercial contract best practices. So everybody's going to encounter contracts in your business, and some of you may enjoy reading them, most of you don't. And the best way to think about this, here's some tips for you. One is to create your own forms and work with your friendly neighborhood attorney to do that. Again, don't pull things off the internet unless you want to visit our litigation team. We'd love to have you talk to them. It's a lot cheaper, as I said already, to do it right on the front end. So creating your own forms, whether it's forms to hire people, it's forms to have your customer sign, could be a vendor form, having the ability to kind of create it once, know what's in it, know that it reflects your risk tolerances, you're you're happy with the areas of exposure, it captures the business terms, and be able to use that on a repeated basis, and then maybe just adjust it to reflect specific questions or comments or issues with one-off employees or customers, etc., is a lot more efficient and again cost effective to do that, and you sleep well knowing that you've gone through it and you're not missing something, as opposed to dealing with a new customer agreement every time you sign up a new customer and getting their form and having to read through it. Or spend a lot of money with your attorney, or again spending a lot of your time, or both, to kind of go through that and make sure you're comfortable with what's in there and even understand what's in there from the beginning. Forms do change, laws change, so you need to make sure you do kind of get those looked at and updated. Certain areas like employment law and other things change fairly frequently. So you want to go through a process to kind of review those maybe on an annual basis. Process third-party contracts efficiently. So to the extent that you kind of educate yourself, and that's part of what I do on a daily basis, is kind of work with clients to create a form, kind of educate them on what's in it so they become pretty self-sufficient about using that day to day in their business. And that's going to help you, or whoever you delegate that to internally, to know when to put the call in, and again, be very efficient both from a cost and time standpoint to process those as they go through. For time's sake, and we do separate seminars on contract negotiation if this is of interest, but everything in there has a meaning. And so I know lots of folks like to just focus on the business deal, say, hey, I'm buying widgets for $10 a widget, and you see the $10 price in there. You see that it says 50 widgets, which is what you ordered, and you kind of sign it and move on. Probably all guilty of doing that one time or another, but each of those provisions in there has some implication for you. And a sentence being in there versus not being in there can mean the difference between your company kind of going out of existence or not. And I'll give you, one of the things that's popping up pretty regularly, and that is folks baking in provisions that, again, oftentimes it's a customer that suggests it to them, that's saying, hey, we're concerned about data breach, big topic. They may have gotten hit by it. Maybe they got hit on the personal side with the credit card, theft of their credit card number, etc. And they're sensitive to it. So they say, you know what, we'll sign up. We'll hire you as our service provider. But we want you to bake into the agreement, if something happens and there's a data breach with our information, you're going to make us whole for that. And so, again, it sounds fair, sounds reasonable. You feel like you have the obligation to protect their credit card information, or their healthcare information, whatever it is you're taking from that customer to process in your company. The issue is if one of those breaches happens, damages can be in the millions. The average claim is in the seven figures. Again, obviously, it depends on the size of the company, but it doesn't take much for a small business of the kind on the call here today to get wiped out pretty quickly. Think to yourself, what would it take if you got a claim in the door to kind of wipe you out? For some, it may be 10 grand. For some, it may be 500,000. For some, it may be more. But oftentimes, it doesn't take much for that to happen. And just a one sentence in the agreement that says, hey, I'm going to kind of hold you harmless and indemnify you and take care of you if data breach occurs on my watch, could mean the difference between that claim hitting you and not. And so, again, one sentence makes the difference. At the end of the day, you want to make sure you understand what the damage limitations are for your business. And there's lots of examples that kind of fall into the lesson learned. Companies who don't realize there's no damage limit in the contract and don't realize that they can be on the hook for many multiples of what the customer, for example, paid you. And the myth on the street is that if a customer pays me 10 grand to provide goods or services and things go terribly wrong, most of them are forced to give back is that 10 grand. Unfortunately, that's not the case. We have things called consequential damages. And so if that customer has been harmed in excess of that 10 grand, which can certainly happen, a quick story we give on that one is if you're in a printing business, maybe there's a printing company on the phone, and they ask you to print some flyers for grand opening of this new restaurant that they're putting together. And you print the flyers, you do it for them, but you have the wrong date. And so no one shows up at the grand opening, and you find that they're coming after you, and you're saying, well, I feel bad, I'll print it again for you, I'll give your money back. And they say, no, we're going to come after you for 50 grand. You say, where does the 50 grand come from? Well, at that grand opening, they hired a band to play. They had a fancy caterer come to host the party. Maybe they had some other expenses associated with some entertainment. And so what was a $10,000 opportunity for you in terms of a customer engagement has become a $50,000 loss. And you can limit that, and you can prevent yourself from being exposed to that by putting in provisions that would cap the liability, that would take away that right to go after those consequential damages. But again, if it's not in the agreement, you open yourself up to all sorts of issues. Lots of you, I suspect, may be dealing with some of these contract terms that you never paid attention to before, but they're now coming up as you try to deal with your landlord, or you're trying to deal with customers. You may be trying to get out of your customer agreement, given what's happened with the economy. And so, that may be, unfortunately, kind of a hard lesson learned about the importance of some key provisions. Lots of folks are turning to their agreements and saying, hey, do I have a force majeure provision that would allow me to get out of this supply agreement, for example, or get out of my lease, or at least leverage that to get a reduced payment because this crisis hit and I can't pay my lease this month, or I can't pay my supplier in full this month. So is there a way to defer that and kind of negotiate something new? So good time to kind of see where your contracts sit and to to find out whether you've got some exposure or an opportunity to create some forms that will really benefit you going forward. Number 9, asking for an unnecessary fight. So again, we typically kind of do a show of hands here as to how many people have been involved in litigation. And I've yet to have anyone raise their hand and say that was a fun process. It's painful, both from a financial standpoint, from a psychological standpoint. Sometimes the latter is more challenging than the former, as lots of clients tell us. I try to stay as far away from litigation as possible, but we've got half the firm that focuses on that type of work. And there's ways to try to manage that threat. And for time's sake, we're not going to talk about all these, but you can kind of read them on the screen here. And most of these are really common sense. Again, lots of these things we talk about today seem really simple. As I mentioned at the beginning, we talk about them because people bring these issues to us all the time. And if you look through there, again, you can read that list on your own. You see that basic things like not having a written agreement, kind of relying on the oral agreement. That's great for litigation, not great for making sure the relationship stays in place as you'd like. Failure to communicate, allowing yourself to get emotionally invested in a dispute and not really working through it from an economic standpoint and what's appropriate. Failing to create some kind of a business prenup or trapdoor so that you make sure you can get out of a relationship if it's not working, whether it's with a partner, or customer, etc. Lots of things that can generate litigation. Another one, of course, since we're doing this presentation with the Better Business Bureau, and as Steve mentioned, I've been with the group on the board for the last 12 years, a big believer in its mission. And I always say, if you have a choice between a good, well-drafted contract or doing business with an ethical partner, if you had to pick, you pick the latter, because those partners will work with you when there's a dispute to try to get things kind of worked out in a reasonable fashion. If not, you can have the greatest contract in the world. If the party on the other side of it is not behaving ethically, they're going to find ways to do things to you, whether it's day one or it's one that you're not going to appreciate, and they're going to break the contract, require you to take legal action to go after them and just kind of make a mess of things. So try to find good people to get into business with. And the strategies, again, not going to go through each one of these for time's sake, but fairly common sense. The one I will call out is the last one, and this is to call somebody, whether you put in a call to your attorney or it's someone on your board or just a close advisor whose opinion you trust. Always good to get an outside kind of third-party check and balance to figure out whether what you perceive as a big deal is actually a big deal. And what we see a lot, especially these days, is people who are behaving unprofessionally. They're being mean to you, but they're not doing anything illegal. They're not breaking the contract. They're not taking actions that would give you the right to bring a claim against them, but they're just not being nice to you. And people sometimes get emotionally invested in that dispute and don't see the difference between those two. And from a legal standpoint, there's a big difference. And so before you launch into a battle and spend lots of time, money, and maybe legal fees fighting it, good to get an outside reality check and say, hey, is it worth kind of going against this third party? Is it worth responding at all? If it is worth responding, kind of what's the deal? Do you settle the issue and move on, or in some cases it's worth a kind of a full-blown fight? But kind of getting that outside reality check can really save you a lot of time, money, and brain damage along the way. The other one I'll hit real quick is just to take informed business risks. And again, this is just talking with your team, whether it's your internal team, getting the understanding from a legal perspective, from the accounting perspective, et cetera, as to what you're getting into with the partner and how that looks. Taking the uninformed risk because you just haven't done your diligence is typically going to lead to bad stuff. So at least take risks, but make sure you know what they entail. And the final lesson learned here is just that people behave very illogically when they get into fights. And again, this keeps our litigators in business, but not good for the people fighting the battles. And that is, people will spend, there's lots of my colleagues who tell me this all the time, where they spend as much as they are fighting about, so if it's a $50,000 claim, they spend 50,000 or 250,000 fighting about 50. And you say, how on earth could that happen? I would never do that. If someone brought a claim against me, why would I spend as much to fight it as it's worth it? I just pay them money. And unfortunately, people get in a situation where the other side is not acting logically, and you make opportunities or offers, I should say, to settle the claim or to deal with the situation, and they behave in a way that just doesn't make sense. And you're saying, hey, I thought this is what you wanted, so I'm gonna give you that, and let's get this done and move on. And you see that they react in a very different manner because it's become personal to them, and they're not thinking in a way that's purely rational from a business standpoint. So that's a very dangerous opponent. And again, an outside reality check can kind of tell you when that's what you're dealing with, and encourage a course of action that's going to make some sense and kind of keep you focused on your business. So the last tip is kind of not planning for a liquidity event. So one of the things that we hear all the time is people, especially entrepreneurs, are so busy, working in and building their business that they don't think about an exit strategy. They don't know how much the business is worth from a valuation standpoint. Every business has a certain type of value. We can't get into for time's sake here, but when you go to sell your company, if that's the plan, or maybe you plan to transition it to the next generation in the family, there's issues and complications that come with all those strategies, and not planning for that is going to inevitably put you in a situation where best case is you don't get as much for the business from a sale price as you hoped. Worst case is you end up having to make a decision at an unexpected time because someone got sick, the market crashed, something happened in your industry that's maybe a big competitor came online, and you didn't have the time to really plan for that event. And you end up, in some cases, closing up shop or selling for cents on the dollar or doing other things that really didn't reflect the value that you put into the business over that 5, 10, 20 or more years that you worked to grow it. So having a game plan and kind of understanding what the end goal is and figuring out how to put that in place is really important. We have a client right now we're working with that feels like they can't sell the company because there's really not any buyers. So the thought is, let's transition it to next generation. And that's great. But the problem is, how are you going to extract value from, let's say, a kid who's taking it over, who may be 30 years old, very smart, able to take over the business and run it, but it doesn't have the cash to pay you, $1 million if that's what the business is worth. So then you have to figure out how are you going to get those dollars out that you counted on for retirement, but that child doesn't have those resources, can't borrow against it because they don't have credit. And so, again, you wanted to facilitate what sounded like a great transition strategy, but now the economics are kind of colliding with reality there and not allowing you to do what you thought you could do. Planning that, at the beginning, or taking some time, over the next few months to kind of think about that exit strategy is important, because again, you never know when that event's going to hit, and it often hits when you don't plan for it. So with that, we're concluded. I'm just going to encourage you to get what we call kind of a legal checkup. And for those on the call, to the extent that you're interested in chatting about one or more of these issues, we're always happy to offer you a free, no charge consultation. So for folks who are in Arizona or in California or other places, feel free to shoot me a message. We can set up a time to do that. As I also mentioned, we have lots of seminars and programs that we hold. I typically do, in normal times, 3 to 5 a month, a little bit less so in the lockdown here, but hopefully we're going to be getting back online. We've got our monthly emerging business seminar series. I know some of you have been to. We're going to restart that in June on a virtual basis, and then we'll see what happens in August. All the seminars are at that personal website there, so you can check that out. And again, happy to connect you up with those resources. They're all free, and you can learn some good content. Pretty much every slide that we did, with a couple exceptions, we have one or more separate programs that allow you to kind of do a deep dive into the topics and get more, kind of get a little more involved in those issues and learn more about them and how you implement some of those things. So again, if those are of interest, please check out those resources and take advantage of those. So I think we got a few more minutes, and I'm happy to stick around to answer some questions. I saw some folks kind of raising their hand. I don't know if we've captured those, or if you want to submit those on the chat block there. Happy to answer those.
So we have a comment and question from Reed. Several of your stories came from the Great Recession. Unfortunately, many new stories come from the current COVID recession. When will
Sure.
you resume in-person work at Snell and Wilmer offices in Phoenix?
So if I understand the question correctly, it's when are we going to kind of get back to work? And we are opening up all the offices that we're actually able to do on Monday. We're not going to have a full crew, but folks who want to come back and kind of get back in the office are going to be able to do so Monday, with the exception of California, where we're not essential employees, as they term it out there. So we're not allowed to go back in the office quite yet.
Great, thank you, Brian. We have a comment and a question. I've heard sexual harassment occurs in virtual work environments. Can these trainings for sexual harassment classes be held in virtual settings, and how often should organizations hold these for their employees?
That's a great question. I don't see any reason why you couldn't do a virtual program. I mean, one of the things we do at the firm, and I believe it's every 2 years, but again, the rules may vary depending on the size of the business and kind of what state you're in. But I know, at least in Phoenix, we have one of our employment partners provide training. Like I said, I think it's every 2 years, and it's not a long program. It's maybe an hour and a half. We typically do it over lunch, and that training, coupled with our kind of our protocols and policies, again allows the business, in this case the firm, to insulate itself from those types of claims and kind of reduce the potential liability associated with those. You can't prevent people from doing things, but you can, as I said, have a response in place that not only protects you legally, but that just kind of resolves the issue as quickly as possible, which is equally important. So again, I don't see any reason why you couldn't do a virtual event. Maybe there's some requirements that it be, you'd be able to see the people and the materials like we're doing here today. But I suspect that that's something that could happen. So if whoever asked that question, feel free to follow up offline, and happy to get you an answer. And we do lots of that type of training. Employment folks do. So happy to connect you up with those resources.
Great, thank you. We have a question. Do you see any new legal mistakes that businesses will make in 2020 after COVID-19?
Yeah, that's a good question. Any new mistakes? I think the big question that we're seeing right now, and we actually have a new set of resources that some of our folks have put together. I haven't myself even gone through it yet. It just kind of came online, I think, within the last 24 hours. But I think what they speak to is how to kind of open the business back up and how to operate in this new environment, which most folks think is going to be going on for quite some time. Even if you go back to work, we're going to have to deal with kind of a new normal and a new approach and new regulations, which are constantly changing. And again, we're going to getting regular updates just internally. Some of you may be on our email list and be getting some of those alerts we send out. So if you see how quickly those things are evolving. So I think the big issue for the next 12, 24 months is going to be how do businesses address this issue, whether it's dealing with employees who are not comfortable about coming back in, or it's dealing with protocols you have to have in the workplace to make sure you create a safe environment, and you help minimize your liability if someone does get sick, etc. So lots of very interesting, like I said, evolving things that are happening. That's going to be where people, if you kind of wing it, good luck. I mean, it's going to be open yourself up to things that you probably don't need to. So this is, again, a place where I would seek some resources. Other than that, I think the other thing that we see people doing that's related is assuming that you're going to be able to get out of your contract or amend your contract or change that. I was just on a call with a client who owns real estate, and all his tenants are coming to him kind of demanding reduction or elimination of rent for a few months, or deferrals or other things. And there's certainly no reason why people can't go and make those requests. I think that's pretty common right now. But there is some kind of some kind of sentiment out there that these things are just legally required, and that's not the case. So I think kind of evaluating your contracts. In some places you can legitimately terminate because things happen. You can't host your events, you can't do your things, and so you can terminate and maybe get a credit or get a refund. In other circumstances, that's not the case. And so kind of going into that negotiation and discussion, knowing where you stand legally is pretty important, because otherwise you may come out with a result that you didn't anticipate. So it's just, again, another good time to if you haven't done it recently, look at the contracts you use for the business and kind of incorporate into those, whether it's the employment side, it's the customers, it's the vendors, provisions that are going to be relevant for this kind of new period of time when the crisis is continuing.
Great, thank you. I think that's all the questions that we have, Brian. I want to thank you again for taking time out of your busy day to present today's webinar. Information is definitely valuable for all of our businesses listening in. So thank you everyone for attending. This webinar was recorded. It will be posted on events.bbcommunity.org, so you can view it on there in 1 to 2 business days. And if you do need to reach out to Brian, if you think of any other questions, you can please email him, or you can send it to me and I can definitely connect you with him as well. So thank you everyone again for attending, and please have a great day and stay safe out there.
Thanks again.